Colorado's Supreme Court ruled former President Trump cannot appear on the primary ballot because of his role in an insurrection, a decision that's sure to be appealed. The court cites the 14th Amendment, Section 3, saying no one can serve as an officer of the United States who engaged in an insurrection or rebellion against the U.S. Now, to dive further into this discussion, we want to bring in Miguel Schor. He's a professor of law and the associate director of Drake University Constitutional Law Center. Professor Schor, thanks for joining us this afternoon.
Thank you for inviting me.
Well, you were telling us about this 130-page decision that you said you read, all 130 pages. I'm not going to ask you for a summary, but we were talking a little bit about this decision and your first thoughts.
Well, so keep in mind the 14th Amendment was a second sort of reconstruction of the United States, an attempt to give rights to African Americans through the 14th Amendment. And one of the things that the authors of that amendment were worried about were that the former Confederates would sort of gain office, and they wanted to prevent that. And that's what Section 3 of the 4th Amendment does, which is that that you may not serve in an office in the United States if two things have to happen. One is that you formally had served in an office where you swore an oath to support and defend the Constitution, which then President Trump had done. And then the other thing is you may not then engage in an insurrection or rebellion or give aid and comfort to its enemies. And the Colorado Supreme Court said that that was satisfied, and it had to jump through a lot of new issues. So one of them is whether or not it is self-operational or not, whether or not Congress has to write a law or not beforehand. That's an issue that will be, if the Supreme Court thinks it will have to decide. And then it's going to have to decide whether or not, whether the speech that Donald Trump engaged in on January 6th, whether or not that is actually engaging in an insurrection, right?
So this is a landmark ruling in that it's the first time that this has ever been used to disqualify someone from running for higher office.
Absolutely, no. This is well, it's happened before for the lower office. It happened, but for the President of the United States in front of an election like this, absolutely, this is a first. And as I said, the trial court had to find, first that there was an insurrection, right, an attempt to stop the Congress from counting the votes, from certifying the election, right? That's what insurrection was. The more sort of difficult question, as I said, is the sort of the speech issue, right? Because speech is highly protected, sure. And whether or not the speech that President Trump actually engaged in at that time actually was, in effect, engaging in an insurrection is going to be a tough issue for the Supreme Court.
Now, you describe this as kind of a blueprint because of its length and diving into this new, I guess, interpretation of law, if that's how you want to say, or using it for this case. But this is the first, but you're saying likely it now won't be the last.
Well, other states will think about it. I mean, it's new in the sense that no court has done it, but it's not new in the sense that there's just a lot of historical data in terms of the discussions. The 39th Congress that wrote the 14th Amendment spent a long time discussing this, and so they absolutely said that, yes, this does apply to someone who wants to be the president. They talked about the kinds of actions that would fall under that. And so there's lots of sort of contemporaneous evidence that it was intended to cover something like this.
Other states are considering this legal argument as well. You said some successfully, others now for the first time successful, you would say?
Yeah, I think this is going to have to go to the Supreme Court. It would be intolerable to have a situation where you have one set of rules for, say, the state of Colorado and not for the other states. And so the Supreme Court, and these are all sort of federal constitutional issues. Is it the case that Section 3 applies of its own force, or must it be that Congress has to write a law? If they decide that Congress has to write a law, then Trump will win on his appeal, right? Then they also have to decide whether or not he was an officer of the United States. I don't think it's a difficult argument. I think the more difficult argument, as I pointed out, would be whether or not that speech actually was the equivalent of engaging in an insurrection, because there is a case there called Brandon versus Ohio, which you cannot be penalized for advocating or inciting violence unless you intend for an imminent lawless action to occur, and if it's likely for that to occur, that's a really tough standard. The Colorado Supreme Court decided that standard was satisfied in that case, but that is clearly something that can be appealed to the Supreme Court.
I know we were talking about you're on break at Drake, but this would be a fascinating discussion in your classes, right? I mean, this is what your current case law right now.
Oh yeah, no, I'm gonna give this Colorado Supreme Court case to them too. I teach a First Amendment class, and I'm certainly going to give them that case for the students to actually read. And this is absolutely something that we will discuss with my students when classes begin in January.
All right, Professor Schor, we appreciate your time looking back at the history of the 14th Amendment and how it could apply in this case in Colorado, and thank you for your insight.
Thank you very much.